and we'll start with duty. By duty, we mean that the defendant had an obligation of reasonable care to avoid causing this type of injury. To determine whether that obligation exists, courts will often ask whether the accident and the injury were foreseeable. In this case, everyone would probably agree riding a bicycle too fast through a crosswalk can foreseeably cause an injury to a pedestrian who is crossing the street. For this reason, the element of duty is probably satisfied. Dudley had a duty of reasonable care to avoid this type of injury to Perry. Next, let's look at breach. To determine whether Dudley breached his duty of reasonable care, a court will probably compare Dudley to the reasonable person. If the defendant's level of care went below the level of care that we would expect from a reasonable person, we would say the defendant breached his duty of care. So using this chart as an example, we would say that whenever the red line goes below the blue line, the defendant's breach of his duty of care caused the plaintiff's injury. In fact, courts discuss two types of causation, actual cause and proximate cause. We're not going to discuss those in too much detail, but actual cause means if the defendant had done something differently, would the accident still have occurred? For proximate cause, we ask whether the defendant's actions were close enough in time and space to the injury. Based on the facts as we understand them, it seems the defendant did cause the accident, because if he had stopped or ridden more slowly, there would not have been an accident. So it looks like the third element of causation is also satisfied. Now let's look at damages briefly. It seems that there's no dispute that the plaintiff was injured as a result of Dudley's actions. Therefore, we can say,
picture the scene. Scotland, the summer of 1928. May Donahue and a friend drop into their local cafe to quench their thirst. Now, May Donahue was partial to a float of ginger beer. So the cafe owner, Francis Minchella, poured half the bottle into a glass of ice cream, leaving the rest sitting happily on the table. Mrs. Donahue was rather enjoying her float, but all was not as it seemed. Look, your eyes do not deceive. That gloopy, grimy sort is remnants of a pesky snail. Mrs. Donahue alleged she fell sick with gastroenteritis and brought a claim against the manufacturer of the ginger beer, Mr. David Stevenson. She claimed that Mr. Stevenson should pay compensation because her illness was caused by the snail bits in the beer. Mr. Stevenson argued that he wasn't liable because there was no contract between them, and so the case was brought to court, where it became a pretty big step on the road to developing the concept of duty of care in the tort of negligence. Before this case, the duty concept was limited to situations which were contractual or similar to a contract. Because there was no contract between him and Donahue, Mr. Stevenson was confident he would win the case before the courts. Unluckily for him, the House of Lords decided to unshackle the duty concept. One of the judges, Lord Atkin, concluded that love your neighbour-in-law should become you must not injure your neighbour, something that became known as the neighbour principle. So even though they were total strangers, Donahue still had a right to expect that Stevenson should ensure the beer he produced was safe from snail bits. The effects of this example still reverberate in our legal system today. A manufacturer has a responsibility to make sure that their products contain no dead crustaceans, animals, or anything else for that matter, that could cause us harm.